4. Compensation, seller choices, and setting expectations. Sarah and the Reynolds have covered a lot of ground. Mike and Jennifer understand the listing relationship. They have discussed who Sarah represents, and Sarah has started identifying property information that needs additional attention. Mike looks at the paperwork again and asks the question almost every seller eventually asks. Okay, before we put this house on the market, what exactly is all of this going to cost us? That's a fair question, and Sarah needs to answer it clearly. Compensation should never be treated like an uncomfortable subject the agent rushes through at the end of the listing appointment. It is part of the employment relationship between the owner and broker, and the seller should understand what has been negotiated before signing the agreement. One of the first things Sarah needs to avoid is describing her compensation as standard. She shouldn't say, everybody charges this, Arizona requires this percentage, or this is what the MLS says you have to pay. The updated Arizona Realtors listing agreement provides a useful example because it expressly tells the parties that broker compensation is negotiable and is not established by law, a realtor association, or an MLS. Again, that's one example of a listing agreement. Different brokerages may use different agreements and compensation arrangements. The important lesson is that Sarah needs to understand the agreement her brokerage uses and accurately explain the compensation she is asking Mike and Jennifer to agree to. Mike then asks, okay, but what about the agent who brings the buyer? Are we required to pay that agent too? This is where Sarah needs to slow down because several different concepts can easily get mixed together. The compensation Mike and Jennifer negotiate with Sarah's listing broker is one issue. Compensation involving a buyer's broker is another. A seller may have choices concerning whether and how seller-paid buyer-broker compensation is negotiated. The current listing form provides examples of those choices, rather than assuming there is one required approach. Sarah should explain the available options under her brokerage's procedures and the transaction documents being used. What she should not say is, you have to offer a certain percentage or buyers won't see your house. That's not an appropriate way to explain the seller's choices. Then Jennifer asks, what if a buyer asks us to pay some of their closing costs? Is that the same thing? No, and this distinction is important. Seller concessions and buyer-broker compensation are different concepts. A buyer may negotiate for seller concessions that can be used towards certain buyer costs subject to the contract and lender requirements. Separately, the parties may negotiate seller-paid buyer-broker compensation. The September 2025 Seller Compensation Addendum is a helpful example because it expressly distinguishes compensation paid toward the buyer-broker from seller concessions. If you mix those concepts together when explaining an offer to your seller, you're creating confusion before negotiations even begin. Mike has another question. What happens if somebody sees the sign, calls you directly, and doesn't have an agent? Do we save money? Maybe, maybe not. The answer depends upon the actual listing agreement and circumstances. The updated exclusive right to sell rent form, for example, contains a separate provision addressing additional compensation when the listing broker performs specified additional services involving an unrepresented buyer. That doesn't mean every brokerage handles an unrepresented buyer the same way. It means Sarah needs to know what her agreement says before answering Mike's question. There's another important issue here. If an unrepresented buyer calls Sarah, that buyer does not automatically become Sarah's client. Sarah still represents Mike and Jennifer unless another agency relationship is appropriately established. She needs to be very careful that being helpful to an unrepresented buyer doesn't turn into giving the buyer the impression that she is protecting the buyer's interests. This may seem like a small distinction during a telephone call, but it can become a major complaint when somebody later says, I thought you were my agent too. Once compensation is clear, Sarah shifts the conversation. Now let's talk about what happens when we actually go active. This is where a good listing appointment becomes an expectations meeting. Sarah asks Mike and Jennifer how much notice they need for showings. They have 2 dogs, so they need a plan for pets. Jennifer works from home several days a week. They have an alarm system. Sarah wants to know whether there are times when the property cannot be shown and how access will be handled. They also discuss photographs and video. Jennifer asks, are pictures of our house going to be all over the internet? Sarah explains the marketing plan before the photographer ever arrives. The updated listing agreement is useful as an example because its broker authority provisions address MLS exposure, photographs and video, signage, lockboxes, offers, and other marketing activities. The point isn't that every listing must be marketed exactly the same way. The point is that the seller should understand what the broker is authorized to do. Mike wants maximum exposure. Jennifer is concerned about photographs showing extensive electronics and personal belongings. That's a good conversation to have before the photographer arrives. Then Sarah reminds them about something else. If anything changes with the property while we're listed, call me. Imagine a monsoon hits next week and the roof starts leaking again, or the air conditioner stops working, or the HOA announces a special assessment, or the sellers receive notice of a lien they didn't know existed. Sarah doesn't want to learn about that information from a buyer's inspector or title company. The listing relationship is ongoing. Information can change, and disclosure doesn't stop simply because the MLS status says active. There's also a connection between what Sarah learns and how she markets the property. Arizona advertising rules require accurate claims and representations. If Sarah doesn't know whether the solar is owned, she shouldn't advertise owned solar. If the Reynolds haven't verified whether their kitchen remodel was permitted, she shouldn't advertise fully permitted remodel. If they aren't sure about HOA fees, Sarah shouldn't simply enter whatever number sounds right. Good marketing starts with good information. As the meeting ends, Mike looks around the room. So now we're ready? Sarah smiles. Almost. They've established the listing relationship. They've discussed agency. They've talked about compensation and expectations. Sarah understands how they want the property marketed and how showings will work. But there's still one major subject they need to address before buyers begin relying on information about this home. Disclosure. And that's exactly where we're going when we begin Chapter 2, Disclose Before It Becomes a Problem. Online discussion 1. Mike asks Sarah what percentage Arizona law requires him to pay as a real estate commission. How should Sarah respond? Answer. Sarah should explain that brokerage compensation is negotiable and should be established through the applicable employment agreement. She should not represent that Arizona law, a realtor association, or an MLS establishes a required commission. Sarah should explain her brokerage's proposed compensation and the services associated with that compensation so Mike and Jennifer can make an informed decision. 2. Jennifer believes seller concessions and seller-paid buyer-broker compensation are the same thing. How should Sarah explain the difference? Answer. Sarah should explain that they are separate transaction concepts. Seller concessions may be negotiated for certain buyer costs, subject to the contract and applicable lender requirements. Buyer-broker compensation concerns compensation paid toward the broker representing the buyer. The transaction documents should clearly identify what has actually been negotiated, rather than treating all seller-paid amounts as the same thing. Why should showing instructions, pets, photographs, lockbox access, and marketing expectations be discussed before the property becomes active? Answer. Discussing these matters early allows the seller and listing broker to establish clear expectations about how the property will be accessed and marketed. It can reduce misunderstandings, protect seller privacy and property, improve showing availability, and help the broker carry out the marketing plan within the authority granted by the seller.